What's up, everybody? And welcome in as we discuss and recap day 2 of Karen Reed's trial. We have our first Boston accent misunderstanding. We have cross-examination for the first time in this case. We will see how the defense attorneys do, especially cross-examining law enforcement and firefighters at the scene of the incident. What did they do right? What did they do wrong? What's the focus of the defense? I think it's going to be incredibly important to break down today. And did the state do a better job of directing their witnesses to tell a story of how Karen Reed is guilty for what they have charged her for? All that and more on today's video. Thanks for joining me. Make sure you guys hit that like button. Let's get into it. So we pick up right during the beginning of the day today with the officer that was on the stand where direct examination finished yesterday. And it's our first opportunity to hear from the defense, to hear how they are going to try and break down this investigation, how they are going to show that this was a cover-up, which is what their theory is, and how potentially the Alberts or somebody in that house was involved and law enforcement worked together in this big scheme to cover it up. There's a number of different ways you can do this as an attorney. You can discredit investigations, officers, firefighters with inconsistent statements, with mistakes in reports, with things that are just wrong in reports, with things that are wrong in the grand jury testimony, with things that they just didn't do that they either bypassed or negligently decided not to do, or like I said, didn't do on purpose. So we're going to talk about all that. There are going to be certain things that seem like they could be innocent mistakes that maybe with some motive behind them could seem like they were done purposefully. Let's take a look at some of the ways this defense team has picked apart this investigation just with their very first cross-examination. And we pick up as they're going through the dispatch report, which basically just shows who showed up when. Seems pretty simple, right? Well, let's see what the defense picks up on.
You arriving, is that right?
6:29 it says. Excuse me, yeah, 6:09, yes.
6:09 and 29 seconds.
Yes, I'm sorry, yep.
That's okay. And then it has Sergeant Good arriving 4 seconds
It's a little fast. We'll slow it down a little bit. So it's just talking about these 3 highlighted times or when the officers arrived.
after you at 6:09 and 33 seconds, correct?
Sure, yep.
So all 3 of you, according to the official document generated by Canton Police Department for this event, has Officer Mullaney arriving first, you arriving second, Sergeant Good arriving third, all within 7 seconds of each other, correct?
Correct.
That is complete.
So it has them all arriving within 7 seconds of each other. No big deal. Highlighted on the dispatch report. One of the first things provided in this case, because these are the first people that showed up to the scene. Okay, lock that in.
Sergeant Good arriving third, all within 7 seconds of each other, correct?
Correct.
That is completely false, isn't it?
Yes.
Yeah, you've looked at
That is completely false, isn't it? And without hesitation, the officer's like, yes. Almost like he knew it was coming, which not a lot of this should be a surprise because these officers have seen this stuff. And I forgot to say at the very beginning of cross, a very effective tool that I love when criminal defense attorneys do, especially if we've taken a day break, is they say, do you want to change anything about your prior testimony that you had yesterday? You lock it in. Did you talk to anybody? Anything you want to change? Anything you want to correct? No? Everything is good? Okay, good. Now that we've locked that in, and here's the problem with that, or I shouldn't say the problem, but why it's a useful tool is if the officer would have said, yes, actually, I would like to change something. It's like, okay, now we have another inconsistent statement to talk about. Why are you changing your testimony in the middle of the day? Did you talk to the prosecutor? Did you talk to your other buddies? Did you text the Alberts? Whatever it may be. And you just make them look just as bad if they do want to change their testimony. So it's an effective question because when he says he doesn't want to change his testimony and you jump right in to this dispatch being completely false, completely wrong.
your dispatch, your dash cam, correct? And clearly, we saw it yesterday. You arrive, and there's nobody else on scene.
Correct.
That was at about 6:10 a.m. that you arrived, correct?
About that, yes.
And then Officer Mullaney actually arrives after you about 6:11 a.m. Is that right?
Yes.
And Sergeant Good does not arrive, according to your own dash cam, until about 6:16, a little after 6:15.
Yep.
All right. So right off the bat, the official Canton Police Department dispatch log, one of the first documents generated in any investigative event, that's completely wrong, right?
The times are, yes.
Well, the times and the orders, right? I mean, not only did Officer Mullaney not arrive first, you arrived first,
That's
and
correct.
then he arrived.
Sure.
So that's two things that are wrong about just that, correct?
Sure.
And then it has Sergeant Good arriving 4 seconds after you, which is also incorrect.
Yep.
He didn't arrive until about 6 or 7 minutes after you, right?
Sure.
All right.
And so your first thought might be, what's the big deal? Who cares? Well, this is just going to be the beginning, right? You can call it nitpicking, you can call it poking holes, you can call it whatever you want. But if this is wrong, and you're going to see there are other details that are wrong, what else is wrong? And can the state really prove what's in any of these documents that they're going to be submitting in evidence? Can they prove that they're true? That's hard.
Have you reviewed this document in the past?
Yeah? No,
You've never seen the dispatch log?
No.
Did you ever seek to make sure that the dispatch log that's so important and so vital in an investigation was actually accurate before it was turned over to the defense, for instance?
no, I didn't.
All right. But without that dispatch log, without your dash cam, we would be relying on your dispatch log to be true and accurate. Is that right?
Other than what I'm saying that what happened, correct?
And do you think it's accurate?
Other than his testimony. And we're going to get into that. They're going to examine him on his testimony, whether or not that's been consistent throughout this investigation. And now he gives him another chance to make a correction. And he says, okay, that's fine. We talked about that being wrong in the dispatch log, and you know how that's no big deal, basically. Is there anything else that's wrong in this dispatch log?
Otherwise,
Not in order, no, it's not. Not in order, no.
other than
And
the
time.
order and the time that the officer's responding, is it correct in all other respects in your mind?
Can you rephrase?
Sure.
Say it one more time.
Let's take away the order and the time that the officers responded. Ignore that.
Mhm.
Is the dispatch log otherwise accurate?
Yes.
Take a look at the left-hand column where it's highlighted in green. What's that address?
Highlighting in green?
On the screen, it's
I'm
highlighted.
sorry. I'm
Oh
sorry.
my,
I don't have the document.
that's okay. It says 32 Fairview.
Did you arrive to 32 Fairview Road?
No,
You arrived at 34 Fairview Road,
that's correct. Yep,
So that even the location on the dispatch log is faulty. Is that right?
sure, yep.
Once again, big deal? Probably not. And maybe he even parked his car at 32 and 34 was ahead, but it's another inaccuracy, right? And he just asked him, as everything else was the same. Seems like just kind of a simple mistake and nitpicking by the lawyers. But is it? Or is there more to them putting a different address to where they responded? And this isn't the only incorrect address that was reported in this case. So maybe there's more to this.
May I approach you?
Yes.
Yep. You testified at a grand jury in April of 2022, correct?
I did.
At that grand jury, do you remember telling the grand jurors what address you actually responded to?
The lights, please.
Don't recall. Probably what I said in the
To
jury.
refresh your recollection, if you took a quick glance
Sure.
at a copy of your grand jury testimony. May I approach you? Honor?
Yes.
Page 9. It says, I'm asking if it refreshes your recollection that you actually testified under oath that you responded to 35 Fairview Road.
Yes.
And that is incorrect as well, isn't it?
Yes.
May I approach?
So on the grand jury, he testified to 35 Grandview. What is it? I can't even remember now.
You responded to 35 Fairview Road.
Yes.
And
Fairview.
that is incorrect as well, isn't it?
Yes.
So that's incorrect as well. And so John says it's across the street or next door. Who cares? Well, the defense has a theory on who might care.
May I approach you?
Yes.
Have you reviewed any of the other officers' reports that relate to your dispatch out to the location that you've been testifying to?
No, I did not.
Did you ever review Sergeant Good's report?
No.
Are you aware that have you ever discussed with Sergeant Good that he wrote in his official report that you responded to 32 Fairview Road?
No.
And of course, we just talked about the fact that the dispatch log lists 32 Fairview Road and not 34 Fairview Road, correct?
Correct.
So none of the initial police reports, not the dispatch log, not your police report, apparently not Sergeant Good's, list 34 Fairview Road as the actual location where you responded that morning, correct?
As far as I know, yes. Yes, sir.
Was there an effort on your part or anybody else's, to your knowledge, to mask the actual address of Brian Albert's house as 34 Fairview Road?
No.
All those are just mistakes.
Yes.
And that's why it feels a little more important. and why the opening statement is so important as a roadmap. Because if you come with the goods and you give the jury what you told them you were going to give them, it makes it more important. So it could just be an innocent mistake, 32, 35. No one reported as 34, which was Brian Albert's address connected to law enforcement. And after multiple times under oath, in reports, documented, maybe there is a motive behind it. And it's just a question. He said no, but now the jury is going to think about it. And Bodie had a good question here. Why doesn't the prosecution just debunk this by bringing in other dispatch notes, etc., with the same inaccuracies to debunk the conspiracy theory? Too complicated info for the jury to get. So I don't know exactly which parts you're specifically talking about here, but as an overall question, why doesn't the prosecution just debunk the defense's theory? Number one, they should, and they have to, because in order to prove it beyond a reasonable doubt, they have to prove that what the defense says is not true. But if they get too far down the rabbit hole of doing that, one of two things happens. Number one, just like you said, it can get confusing or complicated for the jury. But number two, and it can become a trial within a trial. But number two is then you leave the door open for the defense to say, do you see them trying to say what we're saying is not true? Do you see them focusing, acting like we have a burden to prove this case? No, we just did the job they didn't do by talking to the snowplow guy, getting this document, getting this information that they didn't do, which proves they didn't prove this case beyond a reasonable doubt. And so they're trying to shift the burden to us. And you got to be careful about that. You got to be really careful about turning the defense into a prosecutor of their case.
Over and over and over.
Yes.
When you made contact with the victim and the women that you described yesterday, did you see any evidence that any of the women had been engaged in life-saving measures?
Yes.
What did you see?
It appeared that Karen Reed was doing mouth-to-mouth on John O'Keefe.
You saw, I don't want to get too graphic, but you saw blood on her face?
Yes, I did.
You saw blood on his face?
That's correct.
You saw blood in her.
And that's important because that's how people are going to identify Karen Reed later. But he also discusses how Jen McCabe came out and was giving him a narrative, and then how somebody walked into the house, which they proved from his body cam because he doesn't remember it. And again, he was like, oh, it's fine. We have my testimony to rely on. Well, your testimony didn't remember that, but your body cam got somebody walking in the background. You could see walking in front of the car. The defense says it's Jen McCabe. He says he doesn't know who it is. So they have to be careful about that. And then, of course, he gets into Karen Reed's statements, which are a big and important part of this trial. The prosecutor said it over and over again about, she said, I hit him or I did it or whatever it may be, making some kind of admission. We haven't heard anybody testify to this point in the trial yet to that. But the defense, to the officer that was first on scene, let's hear what he said Karen Reed said that night.
All I'm asking you, you recognize
yes.
that as your report?
Yes, yes, sir.
Okay.
Sorry.
Did you write that?
Yes, sir.
So first, this is the report written by this officer that he's reviewing to refresh his recollection.
When did you write that?
I believe the morning of.
So that would be January 29th,
That's correct.
a little bit later in the morning after you left the scene.
Yes.
And you were reflecting back on what had just happened minutes or hours before, correct?
Yep.
And you were trying to be as truthful as possible, correct?
Yes.
You were trying to be as accurate as possible,
Yes.
as comprehensive as possible,
Yes.
and as thorough as possible.
Yes.
You wrote in that report, quote, Karen Reed kept screaming, is he dead? Is he dead? She was severely distraught and not able to tell me what happened. Correct?
That's correct.
Yes.
And so it's a good quote for the defense. Not I did it, not I hit him, no admissions. Is he dead? And important to lock in all those questions. You ought to be as precise as possible. You put everything important in your report. You had more room. You weren't limited in what you could have written. So if she would have said more, you could have written more in there, right? Right. Lock all that in first before you get the statements out that you know are going to be good for your client.
There was no limit to the amount of words that you could put on the page, correct?
No.
Matter of fact, there's a ton of white space. It's left unutilized, right?
That's correct.
You could have taken as much time as you wanted to in writing this report. Is that right?
Sure.
And it was, is that yes?
Yes.
There was no reason to abbreviate anything. Is that right?
No.
And you tried to be as accurate as you possibly could in that moment?
Yes.
and put everything down in that report that reflected what you experienced, what you observed, and what you heard that morning, correct?
Yes.
And the only statement you attribute to my client on that morning, just hours after the incident or minutes after the incident, was she kept repeating, "Is he dead?" Correct?
Yes.
You were interviewed by Michael Proctor the next day, weren't you?
I don't know what day it was, but
Would it refresh your recollection? Take a look at that report.
Sure.
Take a look at that. Recognize it. That's Trooper Proctor's report of an interview that he did with you, correct?
Yes.
And if you look on the second page, paragraph about what you stated to Trooper Proctor.
That's highlighted? Is
I
that-
highlighted it for you, yes.
Yes.
Okay. Did you tell Trooper Proctor, let me withdraw that, ask it a different way. Were you trying to be as thorough and comprehensive with Trooper Proctor as you were in your own report?
Yes.
You weren't holding anything back in that interview, correct?
No.
You wanted to be as truthful and as honest as you possibly could?
Yep.
And as comprehensive as you possibly could, correct?
Yes.
You told Trooper Proctor that you could, quote, hear Karen Reed continually state, "Is he dead?" as the paramedics treated the victim. Officer Seraph then seen Karen inside her friend's vehicle, correct?
Correct.
So the only statement.
So once again, right after, and all this is really close in time to the incident. In his report and what he told Proctor are consistent. That's the only statement. It's good for the defense, fits within their case and their theory. And he confirms all that. He was as thorough and accurate as possible at the time when it was freshest in his mind. So why did his testimony change?
That you attributed to my client the day after this incident was, those 3 words, "Is he dead?" that she continually repeated. Is that right? Yes. Thank you. Fair approach?
Yes.
And this, just the end here, this last minute before we jump to when his testimony changed, is just artful lawyering, because the lawyer, if you've noticed, has said the "is he dead" part multiple times. And now, in a very artful way, he's going to get the witness to repeat it.
In the 2 times that you were asked to reflect back on exactly what happened that morning, on January 29th and January 30th, both times you attributed only 3 words to my client having been repeated continually in her distraught state. "Is he dead?" Right?
Yes.
And she wasn't saying that calmly. I'm assuming.
No.
Matter of fact, you used the word she was severely distraught. Is that right?
That's correct.
When you say severely distraught, we saw part of that on your dash cam. She was emotional,
Yes.
upset,
Yes.
focused on John,
Yes.
trying to save his life,
Yes.
and asking, what was the question that she asked?
Is he dead?
Over and over and over, correct?
Correct.
I mean, that's great. She's there. She's trying to save his life. And she only asked one question. What was it? Is he dead? From the witness's mouth. I mean, that's like, that's really good. That's really good. Azam said, Peter, I think we remember What If Anything from Elaine. To be honest, I hadn't heard it for a while until now. Is it one of the proper ways to ask a question? Yeah, there's nothing improper about it. The interesting or weird part about Elaine is she thought it would get her over an objection, which it really didn't. It was just a different way to say the same thing, but that judge let her. So speaking of judges, Nikki said, what is your opinion of this judge? Honestly, I think she's fine. I haven't noticed anything I didn't like about her yet. I think there were some people that I think didn't like her pre-trial. I don't really know what happened because I didn't watch all those hearings. But I think she's been fine. I think she's let the defense get into plenty of things. Now, what I do think is interesting is they're only allowed to say objection. They don't say the reason for their objection. I love no speaking objections, of course, because that's inappropriate in front of the jury, but at least to say objection hearsay, objection leading, objection outside the scope. She doesn't even allow that, which makes the defense attorney's job easier and harder. It makes it harder because you can't argue the reasoning as to why you think this question is objectionable or improper or irrelevant or whatever it may be, right? So sometimes it can make a judge think of something she wouldn't remember on her own just by saying objection. You're relying on the judge to figure out what the objection is. Now, it makes the defense attorney's job a little easier because I assume I've never had to try a case like this. We've always been able to, at the very least, give our reasoning, one word or even a number, a rule number for an objection, because it's easier for the defense to protect the record, because any objection, I would assume the appellate court would have to assume all grounds for that objection. Because if you object and you say leading and it's not leading, but it might be irrelevant, the judge can let it in and say denied as to leading. You've heard that before. And then they can get into that evidence. And now you've waived that argument for appeal. But if you just say objection and the judge has to figure out on what grounds and say overruled or sustained, well, now I would think the appellate court has to see it as you objected for the proper reason. So they're protecting the record as long as they're objecting. So it's kind of interesting. I don't love that, but just kind of an interesting thought. Is John's mother sitting right behind Karen? I believe yes, but I don't know enough about the people that haven't testified yet to know who's who. Teresa said, wait until you hear that the blood was collected in solo cups, something from neighbors, obtained from neighbors. They borrowed a snowblower from a neighbor also to search. Resident of the home came outside. All right, I think we're going to have to hear a little bit more of this. I may be confused about some of this comment. We're going to jump ahead a little bit now to talk about his grand jury testimony, where, you guessed it, his testimony has changed a little bit about what Karen Read has said in trial and before the grand jury. Why? What's changed and why has it changed?
Let me know once you remember. In fact, on April 14th, 2022, months after this event, for the first time, you said, quote, and these are your words, tell me if I get them right. She, this is my fault. I don't know. She said, I can't believe this happened. I mean, she kept asking if he was going to die, if he's dead. And, I just basically said, we're doing the best that we could, end quote.
That's correct.
Mayor Roach.
Yes.
So Bodie said, I think what is said at the bench is on the record. Yes, it is, but those are only sidebars. Every objection does not go up to the sidebar, because you can tell she's just answering these objections as they're asking questions.
So in April of 2022, for the first time, you attributed the phrase, this is my fault. I can't believe this happened, to my client, correct?
That's correct.
But nowhere in your official report did you say that.
That's correct.
And nowhere in your interview with Trooper Proctor the next day did you say that.
That's correct.
You think that was a pretty important omission on your part?
It was an oversight.
An oversight.
Yes, sir.
That a woman who you made contact with, standing over the body of a fallen police officer, said to you, this is my fault. Dismiss that one.
Yes, I didn't write it down.
He's like, yep, just forgot to put that the defendant admitted guilt. Forgot to put that in my report. Again, I think the defense did a pretty good job in smashing the credibility of that statement that she made any admission of guilt. Because his first two statements that he said he wanted to be thorough, he put it in the report, didn't include that. They only include, is he dead? And then to add this afterwards, again, and this doesn't have to be a big cover up. It doesn't have to be this, huge conspiracy theory just for law enforcement to potentially be pressing. We've seen this in lots of cases where they try to make sure the evidence is good, make sure it all points to the defendant, even without a cover up, because they want to make sure they got the right guy or gal. And there's a little bit of a feel to that in this back and forth about his inconsistent statements.
And then, of
Congratulations, by the way, Maria, to your granddaughter.
course, you testified yesterday, and your statement changed again, right?
I don't
Remember what you said yesterday, these jurors?
word for word.
Well, I wrote it down. Let's see if this helps. Yesterday, you said, my client said, quote, it's all my fault. I did this, end quote.
Yes.
Remember that? But yes?
Yes, sir.
But you didn't say that at the grand jury.
No.
And you didn't say that to Trooper Proctor.
No, sir.
And you didn't put it in your report.
That's correct.
I mean, to just sit up there, it seems like a nice enough guy, but it's like, I would be embarrassed, right? Like, it's my profession. People's lives are at risk, literally. And I just forgot to put potentially the most important statement, the most damning statement in my report.
If you were to testify in another 2 or 3 weeks, I think your statement would just keep evolving.
Objection.
Sustained.
So that objection was for it being argumentative, most likely. And then there were some hearsay objections when he was talking about what the other women were saying and things like that. So then he tries to get into that she said, I left him and never came back home in the dash cam. It was not clear. It was a little bit clunky. Not everything from the defense attorney is smooth, right? You're going to have some hits and some misses. That I didn't feel like landed as well as it could have, as well as I thought it was going to when he set up the question with the dash cam. But showing the person walking into the house on the dash or on the body cam, I thought was really effective. And I thought he locked that in, and that was pretty much as clear as day. And he said he did not hear Karen Reed say, "I hit him," over and over again, or even once. Just kind of, it was all my fault, and those kind of vague statements. And then on redirect, he basically was like, "Well, how you testified yesterday, is that how your memory is of this event?" And he said, "Yes." And he also made a good point. "Did you know any of these people?" And he said, "No." So no cover up from this guy. He wasn't trying to hide Albert's address. He didn't even know Albert. The defense will argue it doesn't matter whether cops know each other or not. They all protect each other, kind of deal. Then the next officer, Stephen Mullaney, he only remembered talking to McCabe at the scene. Karen Reed screamed, "Is that my boyfriend? Is he dead?" And she was making suicidal statements. On cross, basically the "is he dead? That's my boyfriend" more than 10 times. He never heard her say, "I hit him. I did it. It's all my fault," anything like that. Which again, at this point, I'm thinking, why did the prosecutors go so hard at that? That was one of the good parts of their opening, I thought, was using the defendant's own words and admissions against her. Now, I do think she could be like, "I must have done it," like the defense said, and, I must have hit him in a panic. And that doesn't actually prove that she hit him, but I still think it's good evidence for the state. This officer also said he didn't see McCabe go into the house. He didn't know which first responders necessarily were there or not. And he didn't see anybody or hear anybody ask McCabe to Google anything. That was just this officer that we're talking about now. Then we get to the paramedic, firefighter, who I thought was pretty credible. I liked him. I think he got his EMT stuff when he was 18 years old. Seemed cool, seemed to like his job, went in early so, other people could get out in front of the storm. I really liked this guy throughout his testimony. Typically tunnel vision. I thought he did a good job explaining everything. And good enough for the state. The witness I probably found the most credible through direct is also the witness that had this to say about what Karen Reed said that night.
Of those injuries, but when we observed them, they were not. They were immobile. They were very stiff. The ambulance, when we were removing clothing, it was noted that he was all of his digits were very stiff. They were immobile, and it caused a little bit of problems just trying to get clothing off of him, just because they were so stiff.
And taking you back outside of the ambulance just for a moment, when you're sort of initially there and you're doing your assessment, and the 3 females are in your general area, correct?
Correct.
And at some point, you or any of the other paramedics or EMTs on scene ask them any questions about what had happened or anything like that?
So as I was ventilating at the head, there was a small delay in just getting equipment, nothing significant, just enough time that as I was ventilating, I was able to ask, "Did anybody see anything? What happened?" And there was one individual that replied several times, "I hit him. I hit him."
And
one individual said several times, "I hit him. I hit him." Finally, what the 5th witness that we're hearing from, I think it's the 5th witness, says the quote the prosecutors relied on as a huge part of their opening and a huge part of their case, that Karen Reed said, "I hit him." Now, there are arguments against it. I get it. But to this point, we hadn't even heard anybody say it. We actually heard multiple witnesses from the prosecution say that she didn't say that, and they were there and never heard it, let alone 10 times. But finally, we have a witness saying, "I said it." And we'll see if the defense is able to attack his credibility when we get to cross. But let's listen to a little more of his direct.
did you know that individual at that time?
I did not.
Can you describe the individual that said that?
I would describe her as mid-40s, average build, average height. And the other two, very similar.
And with reference to that statement of "I hit him," is that something that she said once or more than once or something?
It was several times.
And as far as the tone or demeanor, how loudly was this being said?
As previously stated, they seemed to be erratic. There was a lot going on in that scene. It did seem to be said over and over and at varying volumes. And then there was just a lot of, everybody appeared to be quite flustered.
And the individual, one of the three females that said that, what, if any, observations did you make as to her face or anything?
The individual that said, I hit him, appeared to have some blood on her face, presumably for attempting CPR prior to our arrival.
And you say presumably attempting CPR.
Well, how did we identify Karen Reed? From the blood. Both sides are using that. The defense to say she was trying to save him. Why would you try to save somebody you wanted to kill? And the state's using it to show that she was the one that said, I hit him.
When you first arrived at Mr. O'Keefe, what, if anything, did you observe any of the females with reference to Mr. O'Keefe?
Mr. O'Keefe was not being touched by any individual when I first got to him.
That happened before he got there. Okay, now let's jump ahead to Cross. And John had a question here. I really like this guy a lot, but that coat comment was well played by the defense. So what does John mean by the coat comment? And here's the defense. It's very early on, and he's going to start attacking credibility from the jump.
So we will, that clothing is then usually left in place. We'll do a quick roll just to check the back of the patient, and then he's usually rolled back if there's nothing found, and it's typically left there. In terms of like big puffy jackets, if you cut a puffy jacket, it just makes quite the mess. So yeah, exactly. It's a disaster. So typically those bigger jackets are just removed, and that is when we removed that type of article of clothing, that's when we noticed that his hands were quite rigid.
So that's what happened in this case.
Correct.
You removed the big heavy jacket, discarded it, got it away from the body so you could better assess the injuries.
Correct.
You remove the big puffy jacket, you move it to the side so you could better assess his injuries. Okay, that's the big puffy jacket. Keep mentioning that big jacket, heavy clothing.
And it was only then, after you removed this big heavy winter coat, that you could assess that his hands were stiff and cold.
We noted the hands, but it came more into light, if you will, when we removed that coat.
Got it.
When we removed that coat, that's when it came more into light. John also said the defense attorneys kept repeating themselves in different ways today. It started to drive me nuts and drag on. I think it all depends because if they're highlighting important points, they want to make sure the jury doesn't miss it. That's one thing. If it gets too repetitive and the jury doesn't like it, like you're saying you don't, well, then obviously that could backfire. But I think the defense, especially with this coat part, like you mentioned, they were talking about this big heavy coat and continuing to repeat themselves on purpose.
And you have as good a memory about that as you do the rest of the scene that morning.
In terms of removing the article of clothing?
Correct.
I did not remove any article of clothing. I was ventilating.
But you remember him having a big jacket on.
Correct.
Okay. And you
So he's trying to lock in that you have as good a memory of removing that big jacket as you do of everything that happened that day, right? Which in my mind, I was writing the note, seems like there's something wrong here. My ears are perking up because the defense attorney's like, so you remember this as much as everything? Because if you say that, then you could throw a shade over everything if he's wrong about that. Even a simple fact, like we've talked about. Some people don't like when defense attorneys nitpick, but they're saying, if you're so sure about this, are you really so sure about that? Same thing John Pryor did in Chad Daybell's case about the upstairs, downstairs. By the way, more on that coming after this. If you watched that video and you had an issue with what John Pryor did there, hang out because we've got a video dropping right after this to dig into that some more.
You remember that as well as you remember the other specifics of the incident.
Yes.
Okay.
Locked it in. I remember removing the heavy coat. You remember that as much as everything else? Yes. Okay, we're going to jump ahead a minute just because he's kind of reviewing some stuff they're going to talk about next. He hands him some pictures, and we're going to continue talking about that big, heavy coat that he's sure he remembers removing.
I don't recall, sir, to be perfectly honest.
May I approach you?
Yes.
Do you recall this being part of, let me ask you a different way. Do you remember somebody cutting this off of John O'Keefe at the time?
I remember the clothing being removed.
Okay. But you don't remember this clothing?
I could say that he had clothing removed, but I couldn't tell you exactly what it was.
And you've just looked at these. This, what I'm holding in my hand, appears to be the front and back of a.
So don't hold it up to him from that distance where he said he doesn't recognize it. You can put it back in front of him. Don't hold it up for the jury, please.
May I?
Yes.
That appeared to be a thin cotton hoodie.
Yeah, that appears to be a thinner layer of clothing.
Okay.
Appears to be a thin cotton hoodie. Not a big winter coat, not a big overcoat, not a puffy jacket that had to be cut off. So that to me is really interesting, and I can't wait to see these pictures for myself. The defense attorney's done a good job of painting a picture in my head, but I want to see exactly what this looks like. It seems to me like this guy looking at his face is like, crap. It's not exactly what I just explained. And I didn't really have a great understanding. I do feel like he tried to walk it back. Like I wasn't the one that took off the clothing, so I'm not possible kind of deal. And by the way, if you've ever had EMS show up something with a real injury, they do cut the clothing off you. I've had, when I broke my leg, they cut pants off, and that is what happens, and they destroy it. They kind of leave it out of the way while they're working, but eventually take it off, get rid of it, things like that. So not too unusual there. So let's continue as the defense continues to try to attack this witness's credibility.
May I approach?
Yes.
Not a heavy coat. Is that fair?
Fair.
Not a winter jacket.
Fair.
Is it fair to say you had a lot on your mind when you were out at that scene, correct?
In terms of just
Saving a man's life.
correct.
That's your credentials are impressive. You were there focused on one thing, and that is trying to make sure that a man did not die.
So now the defense attorney is building him up. You've broken him down a little bit. You got to build him back up and explain why maybe his memory wasn't perfect about all this stuff because he was paying attention to all of his surroundings.
Would you agree that that was your primary concern and your primary focus the entire time you were at the scene?
Correct.
You weren't necessarily worried about what other individuals were doing, correct?
No.
If I asked you right now off the top of your head, tell me exactly the number of law enforcement officers that were there at the scene, probably couldn't tell me, could you?
No.
If I asked you whether or not you remember every single civilian that was at the scene, probably couldn't tell me, correct?
Outside of the three?
Outside of the three.
Correct.
Any other civilians?
Not that I noted.
Okay. Matter of fact, you can't even identify the three civilians other than generally middle-aged, 40s, Caucasian, female.
Correct.
You said all three of them sort of looked alike, right?
Without the only defining feature on one of the individuals was one of the individuals did have blood on their face.
So some of the specifics of that scene, you didn't pay special note to, correct?
No, we were focused on patient care.
So now he's like, thank you for giving me that out. And yes, I agree. I was focused on patient care, and he probably was. And that's the thing that sucks about this. And I still do like this witness, but it's like, he kind of made a guess. And sometimes when you make a guess, even if it's an educated guess, it was snowing. So he said there was a big jacket or big coat. And maybe there was, right? Because we don't actually know. We haven't seen the picture. It seems like the defense got him, but we've got to wait. And we've got to see, how it all plays out. But to me, that's going to be tough if he looks like he was just wearing a t-shirt and we're supposed to believe that, he was outside or going through the snow. Maybe he was just walking from her car to the house. There are other explanations for whatever the answer ends up being, but those were some inconsistencies in his testimony. And he's trying to say, well, if you were so sure about that jacket, can you really be so sure about what she said? If, in fact, this witness is alone in hearing the admission.
Is it fair to say that, specifically as it pertains to what the victim was wearing, your memory might be a little faulty where that's concerned?
Sure.
Okay.
So now he's admitting that his memory might be a little faulty. Not what you want from a witness on the stand, right? But I think he's just trying to be honest. Doesn't have a perfect memory.
I mean, nothing wrong with that. You were focused on something completely different.
Correct.
You did notice certain injuries on Mr. O'Keefe's person, correct?
Correct.
And you indicated on direct examination that once you got him into the back of the ambulance, you, as you put it, you had a quote unquote much better picture of what you were dealing with. Is that right?
Correct.
You testified at the grand jury that you noted that once he was in the back of the ambulance, under better lighting, you were able to tell that he had trauma to the right side of his head.
Correct.
Is that right?
Yes.
Are you talking about the major trauma that he suffered to the back of his head or the egg that you earlier described?
I was more just because it was directly in front of me. It was on the front side of his head.
Okay. So it wasn't the right side of his head. If you said right side of your head, you might point above your ear, right?
Correct,
That's not
yes.
what you're talking about.
I was, and to use my person, I would say right here. So more towards the right, above his right eye.
Right of center, but still on the front of his head.
Correct.
And you did not make any note of another injury on the back of his head.
No.
You talked about the injuries to the right side of his arm, correct?
Correct.
noted that those
Before we get to the injuries of the right side of his arm, I appreciated how the defense went through his injuries with this professional and tried to correlate them to their theory of the story. I'm wondering when the prosecution is going to do that. I assume eventually they're going to line up the injuries on his body with the car to show us how the car made those damage. Even if it's because listen, you got to realize if you get hit by a car going that fast, your body can move around. It can hit different parts of your car. You can have a, recoil or whiplash or whatever, where your face then hits a part of the car, or, you hit your head on the ground behind you, whatever it may be. And they just haven't done that yet. And I feel like the defense has done it at every opportunity they have to try and explain how these injuries fit their theory of the case. Now, if it all lines up like that, who knows? But he does a lot of that. Now we're about to get into a very kind of funny moment here, but also I think a little scary moment for Attorney Jackson when we have our first Boston accent misunderstanding.
injuries appear to be scratches.
Yes.
That's your word, not mine, right?
Correct.
You didn't say that those were blunt force trauma.
No.
You didn't say that they were abrasions.
Scratches and abrasions, in my point of view, seem to go hand in hand.
But the word that you used was scratches.
Yes, they were like furrows down.
Say that again?
Furrows, if you will, for lack of a better term. Just
I don't understand that word.
so if you remove something,
Yes.
like you create a furrow in the skin, is that?
Furrows.
Yes, there you go. Sorry, excuse my accent.
Oh, no. I'm on your turf.
Fair enough.
It's my accent.
So literally they go back and forth and Jackson's like, "Oh, furrow." And he's like, "Yes, sorry for my accent. Out of towner, city slicker." That's what he could have said. "Sorry for my accent, big city attorney." And Jackson's like, whoa, no. I'm the outsider. I'm on your turf. It's my accent. But you got to be careful, right? Because I don't know how the jury feels. We don't know how the jury's going to feel about different accents and stuff. But again, endearing for this witness, in my opinion. This witness handled it flawlessly and is like, "My bad. I got a thick accent, born and raised here," kind of thing. I liked to see it. It was kind of a moment that broke up the testimony a little bit. And then he drops the "my cousin Vinny" line.
I'm so sorry. Boy, that one. It's going to be a meme somewhere.
Hey, my cousin Vinny.
Yeah, got it. All right. So
The lawyer says it's going to be a meme somewhere, and he says, "my cousin Vinny." Furrow. I thought that was kind of cool. It was just kind of a fun moment there in the middle of this guy's testimony. But again, I think it's going to be endearing to him. I think it's going to make the jury like him more. But we'll see if it has any effect.
So when you said furrows, you made your hand in almost like a claw and drug it against your right biceps.
Objection.
Sustained.
Can you repeat the movement that you did for the jurors when you said furrows?
Objection.
Sustained. Just move on to the next question, please.
You would agree that a very common cause of a hematoma over one's eye is being hit or punched.
Correct.
Is that right?
Yes.
You said that Mr. O'Keefe did have such a hematoma over his right eye, correct?
Yes.
Did you also see a laceration under the eyebrow but above the lid on his right eye?
I don't recall.
Did you see a laceration on Mr. O'Keefe's nose?
I don't recall.
You did note that there was some blood on his nose, correct?
Correct.
That possibly that came from a small laceration.
Yes.
In your experience, well, let me ask another question. Did it look like he had, in addition to the egg on the right side of his head, in the front, did it also have a black eye on the left side?
If memory serves correct, yes.
So both eyes were blackened.
Primarily the right side, if memory serves.
Okay. And the laceration toward the right side,
Yes.
of the right eye. Are those injuries that you just described consistent or inconsistent with some sort of physical altercation?
Objection, Your Honor.
Sustained.
So he keeps trying to, and he asks him multiple times. So the jury gets the picture that he is trying to connect this with a fight. The judge does not let him get into it at this point. Even after he comes back up and he's like, "You understand what happens in fights. You understand, how this stuff works." And then eventually they kind of have a little dialogue about it. The witness wiggles around a little bit and doesn't give him the answer that it's from a fight, but does kind of say it's possible that something like this happens from a fight, or it could happen from other things. But it was, again, very clunky because the objections and the sidebar and going through it. It would have just been nice if the witness would have just been, "Yeah, you can have these types of injuries in a fight." Now, what's interesting is the prosecution didn't say, you could have these type of injuries after getting hit by a car, right? I don't know why they didn't, but I assume there's going to be more experts testifying about those kinds of things in the future. And it was really interesting because at first I didn't think, well, maybe he's not going to impeach him. Maybe he's just going to say, well, his memory's not that great about the jacket. His memory's also not that great about the quotes. So maybe he's not going to impeach him with prior inconsistent statements, but I was wrong because Attorney Jackson did decide to impeach him with prior inconsistent statements. But let's listen to how effective these were, or this was compared to some of his other impeachment. And you tell me if you think this is a big deal. The differences potentially in how he relayed the information that Karen Reed made some kind of admission of guilt that night over and over again.
Yes.
Okay. You were asked a question when you spoke to her and she said, I hit him. Were you with the other representatives, sir, there at the time? Were there other people around you? You remember being asked that question by a grand juror?
I don't recall.
So before we get into this too, there's some people asking why those objections are sustained with him reenacting something. To me, I don't know, because if the defense will go back, by the way, it already happened. And so he can say, basically, he said scratching here. And he said, I think he did like scratching like this. So, I mean, he can say even the paramedic firefighter made scratching parts, not scraping it against the ground or something like that. So he could try to go back because that already happened. Now it could be why the objection was sustained. Okay, I wouldn't have sustained the objection as a judge. Start with that. But asked and answered potentially because he already did it. Cumulative because he already did it. Maybe the judge feels like it's irrelevant or the best evidence is in the testimony or the pictures. Those are some reasons. But again, it's kind of weird when the lawyers aren't giving their reasoning for the objections and we're hearing sustained or overruled. So we've just got to act like the judge and try to come up with every reason the objection could be sustained. And if there's one, then we sustain it.
Do you remember answering, no, there were other people around me. I had paramedics Flamati with me. I believe firefighter Kelly was there as well.
Correct. So the three of us were all providing patient care around Mr. O'Keefe.
And you indicated that we were all there together. You were kneeling and you were doing the airway while you called him Tony.
Yes, that's Anthony, Tony. Yes.
All right. He was doing the CPR, correct?
Correct.
And it's absolutely clear in your mind that when that statement was made, you were knelt down over Mr. O'Keefe. Flamati was doing CPR. Kelly was with you guys, and you posed the question to her, do you know him? Correct?
Correct.
Okay. So I want to make sure I understand this. You said, as you're knelt down, do you know him? Directly to the female. And she answered your question with, I hit him.
Yes.
But that's not what you told Trooper Proctor in a February 8th interview.
Okay. I don't recall what
I thought he was going to come with some completely different quote. He didn't. He still says she said it, but the context is a little different. So this is very different than some of his other impeachment, which is why I wanted to play it here.
I told Trooper Proctor.
Let's start at the beginning. Do you remember having a conversation with Trooper Proctor on February 8th?
I do.
That was obviously much closer in time than your grand jury testimony, correct?
Correct.
And years closer in time than your testimony now.
Correct.
Do you recall on February 8th telling Trooper Proctor that while you were rendering aid, you heard Karen say, I hit him, to another female on the scene?
To another female, as I stated, I heard several times I hit him. In terms of who that was directed towards, I mean, again, focused on patient care.
Understood. My question was a little bit different. Do you recall telling Trooper Proctor specifically that while you were rendering aid, you heard Karen say, I hit him, to another female on the scene, and the other female told Karen to be quiet?
I do recall that.
Okay. That's not what you testified to today, though.
Okay.
Matter of fact, that story has changed to you posed a question and she answered your question. Correct?
Correct.
So which is it?
So when ventilating a patient, typically that is also used to gather information from bystanders, because as I'm ventilating, I can real quick look around. Do you know this individual? Do you know anything about this individual? That's fairly typical for any scenario in this. It's a very quick information gathering strategy.
But you'll agree that your testimony today has changed from what it was from your statement to Trooper Proctor on February 8th.
I don't know if it would so much say change, sir. To be honest, I don't fully recall that meeting with Mr. Proctor.
So you don't, I'm sorry.
I remember meeting with him. However, I don't fully remember what was discussed.
So it's fair to say that your memory is a little bit faulty as it pertains to that time frame.
Absolutely.
So again, I'll do kind of two sides to that. Number one, I don't think this was nearly as big of an impeachment as some of the other witnesses. I get it. He impeached them, and everybody that's on the defense side says, oh yeah, another home run by the defense, big impeachment. While some of the law enforcement has been impeached horribly so far, the impeachment of, well, you told one person that you asked her and she responded to your question. You told another person that you overheard her saying it to one of the girls. And his explanation for that is, I kind of asked her while I was working and it sounds like she said it to one of the girls. I couldn't tell if she was talking to me or one of the girls, but I definitely heard her say it. Medium impeachment, medium. But what the defense attorney did do is beat this witness down enough to where this guy is second guessing himself, and to the level that when he was just asked, so is it possible your memory was faulty during this time period? And he said, absolutely, was his answer. I'll back it up just so we can hear that one more time together.
So you don't,
I remember meeting with him. However, I don't fully remember what was discussed.
So it's fair to say that your memory is a little bit faulty as it pertains to that time frame.
Absolutely.
Your memory is a little bit faulty as it pertains to that time frame. Again, not what you want to hear from your witness if you're the Commonwealth, and he has said that multiple times. I feel bad for this witness a little bit, I do. But the defense attorney is doing his job. And even when the impeachment wasn't perfect, he still got the point across that he needed. All right, we're going to jump ahead a little bit more here to the end of cross. First, there was a question I wanted to answer here. So Azam asked, I might have missed this yesterday. Both parties wanted a continuance, but the judge decided to go to trial. Would it be grounds for appeal for either party? Potentially, especially for the defense, if they said they weren't ready and the judge didn't let them and forced them to go to trial when they weren't ready, or if they needed something that should have been given to them before they went to trial and it wasn't, and they could show that it was prejudice and that the judge abused their discretion. We'll see if that ends up happening. Margarita, hi, Peter. Is there a legal difference between don't recall and don't remember? I'm curious about this in every trial. Also, English is not my first language. So Margarita, no, they generally mean the same thing. They just mean you don't remember, or to my knowledge, or I don't remember that, or I don't have knowledge of that, or I can't recall. All pretty much means the same thing. Fire Knight said, why wouldn't anyone ask if he looked like he got hit by a car, or were there any injuries below the neck to his torso and legs? If I was trying to prove he got hit by a car, I would ask, is this consistent with somebody that got hit by a car? We've seen it in millions of trials. We're seeing the defense do it with their theory of the case. John O'Rourke said, did the Commonwealth try and impeach their own second officer with the last smart A comment about if a body is found in your driveway? Not my words. Attorney mentioned smart. I think he said, I don't want to be a wise guy. And I thought that was the defense. I think that was the defense that got up and said that on recross when he said he had one question. Like, did any of the neighbors have a body end up in their driveway or in their yard? Objection sustained, probably because it was argumentative. But again, we're guessing at the reason these objections are being sustained. So that's how I remember it, but I could be wrong. All right, let's go back here now to the way that the defense attorney finishes this cross-examination. Okay, so we've gotten the impeachment, some good impeachment, some bad. We've gotten the bad comment, the admission of guilt from Karen Reed, that the defense obviously doesn't like, doesn't want. And we're getting towards the end. And how is he going to finish this cross? Because he's had a really good start and a really good end to basically every cross, which is a skill and something you should prepare for and try to make happen if you can at all. Let's listen to the end.
We try to stay clear of it just because we are involved in it.
So the answer is, there have been many discussions.
Yes.
Probably daily.
Frequently.
Have any of those discussions helped you with what you earlier described as a little bit of a faulty memory around that time frame?
Objection.
He can have that. Have they?
Repeat the question for me, sir.
Sure. Have any of those discussions helped you with what you earlier described as a little bit of a faulty memory?
Discussions with the prosecutor, have they helped you fix your memory?
Memories that I have and the ones that I'm bringing up, I don't believe that they've changed. You know, I played them over in my head to the best of my ability, and I don't believe my story is swayed. If they've been enunciated incorrectly on my part, that it wasn't intentional.
Understood. And nobody's casting aspersions.
Yeah.
Memory's a funny thing. So your memory is as good about that as it is about that winter coat.
Yes, sir.
Did you catch that? And he even says, like, memory is a funny thing. That's him testifying technically in the Daybell case. That's been objected to when John Pryor tries to do stuff like that. And people hate John Pryor for it, but when it's an attorney they like, sometimes they like it. Sometimes it's all about presentation. But he's like, I'm not casting any dispersions. Again, that's testifying. I'm not accusing you of anything. That's testifying what you're doing. Memory's a funny thing. That's testifying technically as a lawyer, but lawyers do it all the time in their questions. I'm just pointing out kind of the similarities and differences between lawyers people like and lawyers people don't like. Or maybe clients they like and clients they don't like and how they treat their lawyers. Interesting always to me to hear. And I love learning about that and seeing those reactions. But he says, memory is a funny thing. Is your memory about, these quotes about as good as your memory about the jacket was? And he says, yep. I'm not even sure this guy, I think he's kind of like almost blacking out, like get me off the stand. But he just agreed. He's like, yeah, my memory is as good as that as it is about the big jacket, which it was wrong about the jacket. And that's why you bring up the jacket. And some people are saying, I don't know the significance of the jacket right here. We're going to listen to it one more time.
That it wasn't intentional.
Understood. And nobody's casting aspersions. Yeah. Memory's a funny thing. So your memory is as good about that as it is about that winter coat.
Yes, sir.
Thanks.
Memory's as good about that as it is about the winter coat. It's pretty good. It's pretty good. We're going to listen to a little bit of the redirect because on the redirect, they get into the injuries a little bit. I was wondering if they were going to try to connect them. And then they try to clarify the memory issues and listen to how many times their own witness has to ask them to rephrase the question.
Mr. O'Keefe, correct?
Rephrase that for me.
Sure. Poorly phrased on my part. So you have been asked on cross-examination about some things that the injuries you observed on Mr. O'Keefe could be consistent with as far as having been the cause of those, correct?
Correct.
And how many sort of myriad of other causalities or how many myriad of other sort of things could have also been a cause of the injuries that you observed?
As stated, a lot. It's not typically just physical altercations. It could be, again, a golf ball could hit you in the head. That could cause similar injuries.
So he's like, well, what could cause these injuries? Could be a myriad of things, not car accidents. Unless I missed it. I don't think he said a car accident, but a golf ball hitting you in the head. It's like something we know didn't happen. But he also says a physical altercation again. Not great for the state.
And just for clarity purposes, when you were asked about a particular time frame, were you talking about the time frame of January 29th, or were you talking about the time frame of February 8th when you met with Truth Profit?
Sorry, so rephrase that for me.
Let me withdraw that and move on to something else. So just again, for clarity purposes, when you were asked about some statements that were attributed to you to Trooper Proctor during an interview, correct?
Correct.
And so with regard to what you recall differently, is it the statement that the person, the female with the blood on her face, made to you, or the statement of the other female telling that person to be quiet?
So as stated, real quick, down and dirty, I asked, do you know this person? To which I hit him. And then in the background, I remember hearing over and over, I hit him. That was kind of pushed towards the back, and patient care took priority, if that answers your question.
Do you recall specifically at this time?
Because it feels like he doesn't really know what he's being asked. So some of this is confusing, which is not great. If it's confusing the witness, it's probably confusing the jury.
The other statements that you were asked about as far as whether or not the other female told that female to be quiet?
I do remember that, correct.
And the other statement as far as the female with blood on her face, and again, that was the differentiating character between the two females that you observed there, correct?
Correct.
And your memory of that statement is, I hit him, correct?
Correct.
Nothing further.
So at least a good ending there, right? I hit him.
All right, Mr. Nuttall, you are all set, sir.
So that's the end of this testimony. So at least a good ending there by the prosecutor. The I hit him multiple times. She's sure that this is what was said. Fire and Ice said, when the defense impeaches a witness, what does that do? Makes their testimony unreliable? Potentially, yeah. It's all about what the jury thinks and what the jury feels about the credibility of this witness, because in the jury instructions at the end of every case we hear in closing is you have the ability to judge the credibility of a witness as a juror. You can believe all, some, or none of their testimony. The Tommy Bernard podcast. I don't think it was about impeachment as much as the guy saying over and over about his story staying mostly consistent, hammering how confident he is that there was a thick coat, not in evidence. I don't feel like he was overly confident on his own. I feel like he was led to that confidence by the defense because he said, I didn't take off any clothing. I was doing other stuff kind of while that was happening. But again, if we were on the jury and we saw that differently, that's possible. It's absolutely possible that 2 jurors would see that differently. Then the next witness that came up was another firefighter paramedic, and we got basically the entire background and education and experience about what paramedics do and EMTs and firefighters that we had just gotten with the prior witness. I feel like the prosecution is asking so many details that are not relevant. I mean, everybody knows what paramedics and EMTs do. You could do that background in 2 minutes. And you really only need to do it with one witness. And if you do it with multiple witnesses, you can do an abridged version. Get to the facts of what they saw. Prove your case. Prove to us that Karen Reed did this and how you know she did it based on what people found when they showed up. And we really barely got into this guy's testimony because it was just basically the windup. That's all we got today. No court the rest of the day today. No court tomorrow. So back Thursday with more of this trial. Really interesting lawyering going on. A lot of crazy details in this case. Impeachment. Tommy Bernard podcast said, double-edged sword. Either Jacket is missing from evidence or the witness memory is wrong or double win. Jackson is a beast. I agree with you there. I mean, he's taking these parts and he's hitting them. He's hitting them hard where it hurts. And again, a bunch of people agreeing that the prosecution is wasting time. And again, I hate to say that they're wasting time, but it just feels like if you got good stuff, put it out there. These are your first couple witnesses. These witnesses should be the best. Now, usually the investigating officer would be early in the trial, but we probably know why the lead investigator is going to wait. They're probably going to try to hide him somewhere, would be my guess. Netwoman, thank you for the super chat. Is the reason that he couldn't do the claw motion again is because he can only testify to his expertise and he's not a qualified expert as to how the injuries occurred. Thank you, Peter, for doing all our lives on this. This is a great case to follow. Please continue this one. Thank you, Netwoman. Yeah, the plan is to continue this one. Hit that like button, you guys, if you're following this trial and want to continue following this trial. So witnesses are usually allowed to demonstrate certain things, especially if it's going to aid the jury. I think he's got enough expertise to demonstrate something like this with his background as a firefighter, EMT, paramedic, dealing with injuries. He saw it. He was explaining the word that he was using. It was helping aid the jury. I don't have a problem with him acting it out. I don't know why the judge might. But he did do it once already. So my guess would be cumulative. My guess would be, asked and answered kind of thing. But I don't know. And that is one of the frustrating parts about this is we could think of a bunch of different ways as far as, maybe lack of foundation. I think lack of foundation was the question about the fighting and why at first the judge didn't let him get into the fact that an altercation could have created these injuries. But we'll still see how these are connected because I think there's going to be a lot of medical experts and accident reconstructionists and people like that that are going to be able to really dig into detail on that. So I appreciate you guys joining me. Don't forget to hit that like button. The Chad Daybell trial, did John Pryor lie in his questioning, is starting in 1 minute. So turn that auto play on and you'll be automatically redirected to that video. But that's all we've got for this one. Welcome to Upside and all the other new members. Thank you for joining. Thank you for everybody gifting memberships. We'll be back tomorrow with more. So until then, actually just for about a minute, I'm out of here and then I'll see you in the next video. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.